So I'm Helen Reid, I'm the Head of Operations here at Bristol Law Society. And as I said, we've been running this series of lunchtime webinars on a variety of subjects now for about 18 months. So do keep your eyes peeled if you're not signed up to our YouTube channel or to our newsletter, particularly our monthly newsletter, which sends out all our events. Then do have a look on there, and that will keep you updated. The webinar today is in association with Landmark Information Group, and we've got Ali Parsons joining us. She's on my top left-hand corner. I'm not sure whether that's the case for you all, but Ali is the customer success consultant at Landmark, and she's going to be steering you through next steps on environmental and flood reports, plus ground stability, energy, infrastructure and planning, and why it's important to ignore gaining further information. We also have Liberty Howe, who is the Client Services Executive at Wessex Searches, and also Chris Harrop, who is a developer, is the Developer Services Manager at Wessex Water, and Chris is going to be speaking to us today on explaining what process to follow if queries are raised in regard to pipework and build over legislation following a search result. So we've got lots of expert advice and information coming your way as to how to take further action and next steps when you're looking at the result of some of these searches. Just to let you know that the webinar is recording. We can't see you, but hopefully you can see and hear us. And in a minute when I go quiet, you won't be able to hear that scratching in the background. Apologies, that's my dog. Again, things we didn't used to have to deal with in meetings. But just to say, as I say, you'll definitely get a copy of the recording and the slides. You'll see at the bottom there's both a chat and a Q&A function. If you've got any questions that you'd like to add or comments, then we'll pick those up probably towards the end. But I'll keep an eye on them, and then if they seem particularly pertinent, then it might be that we raise them in between two sessions. We'll just see how that goes. But I think we've got a good number of people in here, so without further ado, I will hand over to Ali, who I believe is speaking first today.
Okay. Hopefully you can see my screen. Yep, all good.
Yes.
Excellent. Right, okay, thank you, Helen. Good afternoon, everybody. Thank you for joining us today. As Helen says, I'm Ali Parsons, Customer Success Consultant with Landmark, and tomorrow I'll be celebrating 13 years of being with Landmark. I've got to say a bit experienced. I've just been at it for quite a long time. But over the years, a common theme that we've got from the calls that we get through our customer service teams are, and that might come from search providers, from conveyancers like yourself, and even home buyers, are often around further actions. And these might be anything from why have I got one, to what do I do next, or what other information can I find that will give me peace of mind that my transaction will go through, or equally won't hail a problem further down the line. Let's see if I can get my slide to go. There we go. So over the next 30 minutes, and I'll try and keep it to that, I'm going to cover really why further actions occur in the first place, what next steps you can do to uncover further information or ways to mitigate the risk, and to simply understand the hazards that are raised so that you can advise your clients about any issues. We're going to focus really on contaminated land and flood risk, as they're the sort of core things, and the two areas where we get most frequently asked questions about that, alongside ground stability, actually. But you know, if we can help you to help your client, then this can only be a good thing, because further actions don't come along very often, but when they do, they can be most annoying. I know, appreciate sort of stalling a whole transaction. And if nothing else, hopefully we can get your clients to also simply read the report and further past the front page. So let's start with contaminated land then. Landmark reports, like any in the market, are designed to follow a risk model, of which we then screen out vast majority of properties where we can be confident that the property won't actually meet the legal definition of contaminated land under Part 2A liability. Now, that doesn't necessarily mean that there won't be any contamination at the property, but even if there is, it wouldn't reach the threshold of the legal definition. And contaminated land is highlighted where there's past industrial processes, waste disposal activities, military activities, or accidents that may have released substances on or in the land, and which then, of course, will be harmful to human health, damage property, impact ecosystems, or pollute water, so be it coastal surface or groundwater. Of course, much of the contamination that's revealed in this country comes from our legacy of industrialisation. Contamination, for example, in Bath in 2010 actually dated back 100 years before that. And across the UK, lots of different stories, very similar stories from far back as the 17th century. I think we even uncovered plague when they were doing the Crossrail piece first off, and right up to recent times. Hence why we had legislation that was placed under the Environmental Protection Act in 1990, and then the statutory guidances that followed, so that we ensure that any issue relating to contamination is understood and, if necessary, dealt with. And it's always worth remembering that contamination can travel, so sometimes you just really do need to look beyond the property or site boundary, particularly on commercial sites, for any potential issues. So, because contamination can go from, if you've got groundwater, it can travel from one area to the other, and there's some big cases along that view. So if your landmark or Algar report has a lovely green past under the contamination piece, then nothing else to worry about. And you're supported by our remediation insurance feature as well. However, if you do get a further action for contamination, then that means that we need further evaluation to make sure that we've uncovered something that needs to be dealt with, or that actually can be changed and we can change that to a pass. So our recommendation will always be, to contact the local authority to see if there's any records to show if the property was tested for contamination before the building was built. And this is usually in the case where homes were built from sort of 1990 onwards, following the legislation. And in the majority of the cases, planning authority will be able to confirm that either the site was cleared for contamination, or that contamination was identified and then remediated before that current building was put up, so to speak. However, there are, in a minority of cases, there will be the local authority won't have any information, and therefore it'll be necessary for us to carry out some physical checks. And those will usually consist of a phase 1 walkover, or possibly a phase 2 intrusive study. That's where we would take soil samples and analyse them for contamination. And if a site is found to be heavily contaminated, then the purchaser and everybody else involved will go into negotiation about how the remediation should happen and who's actually going to pay for it. And it's important also to realise that even if the council hasn't taken regulatory action for the property at that point, it may still do in the future. So how do we get the result? Well, Landmark has created the UK's largest database of historical mapping, along with other land and property data, to understand both current and historical land use. Because we're looking for those, industries from the past and present, waste practices and waste breaches that may highlight a risk of contamination. And often if you see the word tank is on the map or within that data, that will hail that lovely further action, because tanks usually hold something nasty and have often leaked, and if it's leaked, it's got into the soils. And as I say, land contamination is associated with past industrial activity. So if these harmful substances can still be present, these can pose a potential risk. So with any land identified as having historical works usage, the expert view of an environmental consultant would determine if if it presents a potential risk for Part 2A. So as you saw from the slide, we will firstly screen the data and the mapping. If the risk model highlights a high risk, then a consultant will review that data and mapping, and then make a call to either pass, feels it okay, or give you a further action. One of the valuable databases that we hold now is the Risk Assessed Land Register, and this was launched back in April 2015. We were the first data provider to do this, and it's a live data set that greatly improves the efficiency of transactions for everybody involved, especially in case of new developments, which traditionally, you know, were problematic from a search perspective, you know, because you could be you know, look at a site like this and you're searching on number 1, you go through all the piece about the further action and having to find further information, etc., get it passed, and then, you know, a few weeks later you're now acting for number 10 and you've got to go through the whole same thing. So this register has now allowed us to kind of bring that to a much less further actions, because the risk of contamination or pollution is assessed, verified, and when passed, then is fed into that register for future reference. So it's then can be used on that same site to ensure that you don't get further action, and that actually a consultant doesn't need to get involved either. So bringing down that whole piece and time piece of getting that information back to you quickly, which can be only a good thing. But what do you do if you do get a further action? Well, there's 3 options that we would always suggest that a conveyancer can choose when you get a further action for contaminated land. You can insure against the risk. It's you know, a popular choice to do and quite cost effective. But remember, if you do this and you've already gone down the route of sourcing further information from the local authority, that insurance risk policy will be invalid. So you either do one or the other. So you either insure it or you obtain written documentation to help us give you a pass. And we would do that free for you, the free further action report review with the sufficient further information. And I'll go through what we will accept to do that. And if that information mitigates the cause of the original result, a new pass result will be issued to you, and then all that information is then gathered, put into the risk register for future analysis. Excuse me. Alternatively, we can procure the information on behalf of yourselves, and we're happy to do that, and of course there will be a small fee for doing that, but it's available for you if you want us to do that. Thirdly, site investigation. As I said, these are mainly on commercial sites. And if this is necessary, Argyll Landmark in-house consultants can advise on the next steps to follow. Now, we will always discuss first, and before we take any further steps with regards to a site investigation, but you can do that, and the consultant's name on the site solutions reports, for example, will guide you to the person that had written that report, so that you can make sure that you get guided to the best way forward. So we want to turn your environmental report from a further action into a pass. How do we do this? Well, we can accept the following that are on the screen now. So a building warranty certificate or an HB certificate, or cover note actually, that is dated from 1st of April 1999 and for the actual property searched on. We can accept a written comment from the Environmental Health Department within the last 3 years, but that must include information about past industrial land use, if applicable from landfill information as well, like fill materials and the dates of the infill, any site investigations or remedial works that covered out at the property or close by, information on pollution incidents or records of contamination, whether there's any concerns regarding ground conditions on or adjacent to the property site, or whether the site has been risk ranked in accordance with the contaminated land strategy, which they kind of use a category of 1, 2, 3, 4. you know, high, medium or low, basically. For planning department, you can use planning permissions for the site that include conditions associated with contaminated land, and this must be accompanied by written confirmation from the authority that any relevant conditions have been fully discharged. And of course, where necessary, when we're talking about those nasty substances, the petroleum officer, a written comment from the licensing officer confirming the safe removal of or decommissioning of the tanks. And you may also need to have a written comment from the Environmental Health Department. You may be requested to include that alongside that petroleum license information. Now, we're not here to make things awkward, and I know sometimes when people get further actions, they feel that we're not helping by not accepting certain bits of information. But on the screen now are those that we won't accept. Clearly, as I've said, we need the NHBC certificate to be post April 1st, 1999, so nothing before or for a different property. Local land searches, your Con 29, they're formal entries for specific recorded incidents, but they don't look at any detail with regards to past land use or any potential for contamination, so it wouldn't be sufficient on its own. Geotechnical site investigation reports, they're usually carried out to determine aspects of information around ground composition, and they rarely have anything to do with soil ground testing for contaminants. We don't accept competitors' reports, sadly, and believe me, we do get these sent to us. We can't do that. They use different data sets and methodologies, and we can't provide a certificate based on results from somewhere else alongside our methodology, so we won't accept that. And planning conditions I already spoke of, you know, we need those two parts for that information. All of that that I've just spoke of is actually written within your reports. It's also on our websites, the Landmark Information Group and the Landmark Academy for further information. Now, flood risk is one of my passions, not because I like to see flood risk, but because I've experienced it, and, you know, kind of really passionate that people do understand about flood risk or potential flood risk for now or the future. And flood risk gets identified with reports such as your EnviroSearch residential or your site check assess for commercial, and it identifies those hazards by doing an automated flood risk screen from data sets such as Environment Agency, JBA, BGS, which cover river, coastal, ground and surface water, and their risks are identified. We then provide you with information that for you to get further information for us to make a better evaluation. And the biggest question that we get asked is, well, I've had an EnviroSearch and it says that I've had flood. Now I've had a landmark flood report and it tells me it's all good, and I haven't. The difference between those two reports is that landmark flood will provide a better insight and a further assessment of the data, and also benefits from intervention of environmental consultant who will be able to look at those high risk sites and give a manual review of all the data and the mapping. It will look at defences that are in place or not in place, as the case may be, and it will look at historical flooding. And they're there to seek the real risk behind those clear flood features that have been identified in your environmental report, which means that they can turn a fail into a pass at that point, or to a pass moderate being that at this point of the time it's okay, but they've recognised that there may be some changes in the future that could change the pattern of that flood risk, for example, and they're giving pre-warning to that. So the main difference between your original screening and the second is that the landmark flood report will give you an assessment of all that data and provide a viewer for you to actually look at the risks as well, and allow you to make decisions of that going forward. Now, if you don't want to have two reports, you can have just one report with all that in, and risk view residential or site check combined reports for commercial have both contaminated land and flood risk with that consultant's intervention in there and all the data and analysis. So you need only get the one report, but the preference is there. If it's not identified, you don't need to take a second report. So again, this is how the assessment works, very similar to that of the contaminated land. So once you've ordered it, it goes through data screen and mapping screen and highlights or any risks, and will give a pass or go through to the consultant, as we've already said, and they will take the view and provide you with a further action or hopefully a pass. And that consultant's review really does help reduce the amount of further actions that we have. It's 4 to 15% of all the reports that we go through have a potential for high risk. By going through that model of using consultant, that's reduced by 45%, and even just over 7% of requiring high risk with a further action, really. So if you still get a further action, what do you do? Well, your next step's really to read the recommendations that are on the report. The reasons that a high risk of flooding has been identified is usually because there's a flood event that's happened and has been registered in the past, because there's water close by, so flood water storage, aquifer, or simply because it's possibly that the defences aren't good enough for the area that it's in. And a further assessment is recommended to clarify the risk of flooding at that site and the impact, obviously, to this property. This is the sort of images you'll see if you go onto the viewer or within the mapping of landmark flood reports. And that area that you can see there is designated as a high risk area by the Environment Agency. So clearly something to pay attention to. What you need to understand is how that will impact the property, and you would possibly want to seek further information. So our first step would be to make sure that you look at the viewer, look at the detail, and make note of any questions you want to ask to get further information from. Insurance, despite the sort of risks that are identified, flood insurance is available for most properties, residential properties, and it's quite affordable. But if you've got a high risk site, you need to know if it's eligible for a flood scheme, and you will see there the link to that, and that's within the reports as well. And I always make a point of this, we always recommend home buyers obtain buildings and contents insurance sooner rather than later before exchange of contracts, because one of the majority of calls that we get are from home buyers who've got to the point of exchange only to find out that their insurance company feel there's a flood risk and are asking for further information. If you can get that dealt with early on in the process of the transaction, all the better. But thirdly, you can call the consultants. You can do that via the customer service teams. Get in touch with us to discuss what's on the report, how we can help and advise. It may be that you can have a further report which looks at the types of depths to the property and how that water may impact. Or it might simply ways of how to mitigate the flood if it is, most likely to hit the property. All of this knowledge is important for your clients to understand before they proceed. But we're there at the end of the phone. Please ask. Now, if you or your client like detail, then the site solutions reports kind of take out that risk model piece, and a consultant writer is there right from the start to write the report. So they will review all the data and historical mapping. They write the report, provide an assessment of the risk and liability, and provide a professional opinion along with some commentary. It then will have a consultant's review from an assessor, who then will check the report's content and risk assessment and either agree it or discuss with that writer how they might change the result. And that might be, pass, moderate, for example, or further action. But it means that it's getting checked twice. And all the data and maps are reviewed for both for current historical and proposed use, land use, so it's covering all the detail and the areas. So these reports are used widely by commercial lawyers for that very thought of that detail, and Landmark are the only provider that do this with that expertise behind the reports. You know, the value of that is that you're getting a manual approach right from the start. It's very relevant to the property, which means more passes, less further actions. Now, with the other risks or hazards, I might say, that come up with environmental reports, so ground stability, energy, infrastructure and planning. Again, they'll come up in your environmental report. They've been screened and identified, and then you can take further information. Ground stability follows flood risk is one of the main things that people ask about. People get concerned. They want to know if they're going to go down a sinkhole, or the land, you know, there's going to be a possibility of landslip or mining underneath them. The reports are designed to highlight those very things. They'll call out if you need a coal report, if it's, you know, to say mining or non-mining, so natural hazards, and what if further information you might need. And the further detail looks at, for example, the mineral or mining activities, confirms soil types, maps the features, so you can see the proximity to the property, and explains any potential risk or impact of the conditions to the property. Plus it provides subsidence claims, including those from coal, so that you've got a valid history of what's happened nearby from any issues that may have happened and been claimed on. And then we do obviously recommend next steps. Now, one example, if you've got high potential for natural ground stability, you need to understand the difference in the subsidence. So if it's active subsidence, it will be dependent on the conditions, local conditions, the soil type, whether there's proximity of trees or areas where trees have been removed. And at this point, we usually advise house buyers survey these actions to look for signs of any property damage, and that may have been done already in the transaction. But you know, you need to check it, you know, those cracks in the walls, that sort of thing. And if you know it is active, then you need to inform your insurance company or mortgage lender, or even landlord, and get specialist advice from qualified experts such as your structural surveyor or geotechnical engineer or geologist, engineering geologist. If your property has been identified in the area that is used for mining or mineral extraction, obviously if it's coal mining, then you'll need your coal report. But otherwise, we would recommend you speak to a local RICS surveyor and review any available geotechnical surveys. You know, we're not experts in ground stability. We're there to highlight this risk, but we do work with these people. So you can get information also from the Minerals and Waste Officer at the ground, at the County Council offices. Now, again, all that information is written in your report and available to you and your client to decide what to do to take the next steps. With energy, infrastructure and planning, these are well, not necessarily infrastructure as much as energy and planning, very subjective views, but equally important for clients to understand. And again, we identify if there are any of these projects close to the property being searched. We're looking for sources of energy like wind, solar, fracking or renewable energy, and whether there's things like HS2, Crossrail, overground and underground railways, and even the Southampton to London pipeline. So all those things will be searched. The report provides information around you know, of the further information around who owns those projects, maps it also, it gives clear details and proximity to the, as I say, to the property and the likely impact, if any, to that property. And with planning, again, very subjective, but what we found from recent surveys is that home buyers do have a real interest in planning. I think it's the one thing that they do understand might change from, you know, around them, and some won't mind change, others will hate it. But obviously the next step when you have applications highlighted will be to check the local authority planning portal. If you use the Risk View Residential, you can view all of that on the online viewer, and it's interactive. That means you can, on majority of cases, link to that portal from the links within that viewer. All our large developments are, or majority of our large developments are done as polygons, and this helps provide a clearer view and understanding of the potential impact from those large developments to the said property. And say some people might not mind that there's a huge development happening, others will be concerned, but it makes it clear, you know, you can see that the size compared to just seeing a dot on a map. Also on the viewer, you've got a date filter, because we go back 7 years for planning, and that might be highlighted on the report, but actually, you know, they can view it and see it and it doesn't seem to worry them. But you can have a look on the date filter and you can filter that down to, you know, just for the last year or the whole 7 years if you're required. It's all there, all available, and the information is within the reports. So coming to a close now, on the screen are frequently asked questions. So I checked with customer service teams, and flood risk, ground hazards seem to be the main topic, and the ones in the orange are from home buyers. And those are the 3 questions we get asked most by them. The ones in the purple dots are from conveyancers, and very much around re-reviewing environmental reports and getting that further information. Hopefully I have answered all of that within the presentation that I've just done, but if you have any further questions, then I'm happy to answer these once Wessex have done their presentation towards the end of the session. And finally, I'm just going to finish off with a few tips. You know, like especially after last year, less calls from home buyers is what I hear a lot. The majority of the detail, as I said, is within the report. If you can guide them by highlighting any next steps along with the potential risk that's identified, that will help them decide what to do. And, you know, make the information clear, provide as much information as you can, and one with an assessment of the risk data, and that will deliver the detail along with that review by a consultant. And if you need to call us, you can call the customer service desk, or you're guided to the Argyll consultants for that expertise. We've got lots of documents that can help you around client care information and frequently asked questions and further action guides. And the Landmark Academy actually provides all the information on everything that I've spoke about today, plus all our reports and learning about contaminated land, flood risk, ground stability, etc., is available through the Landmark Academy. So thank you very much for listening, and I will pass on to Liberty now for her to introduce Chris for their talk.
Hi everyone. Firstly, I'd just like to say a big thank you to Ali. I really enjoyed listening just then, and I hope you did as well. If you would like to find out any further information about Landmark's reports, I will be popping our contact details and a link to our website where you can order those reports. Next, I would also like to welcome Chris Harrott from Wessex Water. You may recognise Chris as he has presented to Bristol Law Society in the past. Chris's current role is the Developer Services Manager at Wessex Water, and I have to say there's not much that Chris doesn't know about sewers. So I'll now hand you across to Chris, and there'll be an opportunity to ask any questions at the end. Thank you.
Thanks very much, Libby. You're too kind. Quite something to look up to. Quite a reputation to look up to there. Bear with me. I'm just going to share my screen. Let's make sure this works. Where's the window? Great. Can someone confirm that you can see? Hopefully, you can see the PowerPoint slides.
At the moment, we've just got a frozen screen, Chris, at my end.
Okay, I wonder what's gone wrong there. Bear with me. So if I'll try again.
I think hopefully, yes. And I think if you just put, that's it, perfect.
Perfect, thank you very much. Not sure what I did the first time, but thankfully that didn't take too long to resolve. So yeah, thanks so much, Libby, for the introduction. As I say, my name's Chris Harrop. I'm Developer Services Manager at Wessex Water. Worked here for 12 years or so now, unbelievably. Don't know where that's gone. 4 years in my current position. I look after teams that handle sewer connections and supply connections from predominantly smaller developments, and also sewer buildovers for developments of any size, which is what what I will be talking to you all about today. Specifically, sewer buildover agreements in the context of the conveyancing process. So it's focusing in on those, and I understand that it's an area that generates a fair few queries, and that's obviously the last thing that you need for you and your clients. You need certainty. So what I'm hoping to do is to provide an overview of the process and to to answer some of those common questions, which is what the session aims will largely be based on. So I won't read all of these questions out verbatim, but these are the ones that Libby kindly shared with me before today, and I also spoke to my team as we received some of these directly from you and homeowners. So typically there'll be questions like, can I have a copy of a buildover agreement? When was the sewer adopted? If there's a sewer beneath an extension, was a buildover agreement needed when the extension was built, or the building, whatever it might be? Would there be any risk or liability for your client if they were to purchase the property? You know, what would happen in a worst case scenario if a sewer was to fail beneath a building? So we'll do quite a bit on that, and also finally at the end of the presentation I'll talk to you a little bit about what you can look out for if your client intends to potentially develop that property in the future. I know that a lot of people do buy properties with the intention of doing so, and if there is a sewer located within the land, then obviously they want to understand, broadly speaking at least, what Wessex Water may or may not be willing to allow. So all of these questions I hope to answer in the next 25 minutes or so. So to start things off then, starting at the beginning, what are buildover agreements? Well, they are the different water companies do it in slightly different ways, but they're either a legal agreement between the water company or the landowner, or more commonly they take like a form of consent, so an exchange of letters between the two parties. Wessex tends to favour the latter, so letters of consent between the two parties. We tend to reserve formal legal agreements for the more strategic assets, if those in these fairly rare circumstances that we allow strategic assets to be built over. But we loosely refer to all of that as an agreement for the purpose of this presentation. When are they needed? Typically, it's when you are building over or within 3 meters of a sewer that is owned by the water company, and that easement increases to 6 meters for strategic assets. Now, we do have a layer on our GIS system so that strategic assets are clearly shown. In terms of why why the process exists, so there are benefits for both the water company and the landowner. From a water company perspective, clearly we need to manage the risk of damage to that asset. So that can occur during the construction process, and it can also occur once the building has been built. So if the foundations have not been built correctly, for example, over time that could put structural loading onto the sewer, and then it could cause it to fail. We're also looking at future access. Typically, we access our sewers for day-to-day maintenance via manhole chambers. I'm sure many of you or all of you will have seen those dotted around the place. So we need to ensure that we have adequate access to the sewer once it's been built over or indeed built near to. From the homeowner's perspective, going through the process correctly brings peace of mind. Nobody wants to build a brand new kitchen or whatever it might be over a public sewer, only to find that there are issues that then arise and we have to dig through the floor or take down the building and rebuild it. Whatever, although those are worst case scenarios, they can happen. And so by going through the process correctly, engaging with Wessex Water, then that can bring peace of mind to the landowner as much as is possible that those risks have been managed. And finally, protecting the structure. So with large diameter sewers, there are some rare circumstances where if one of those was to completely fail, and this is, as I say, very rare, then that could undermine the foundations of the structure that lay above it. Depending on how those foundations were installed. So for all of those reasons, the process exists, and that's why we have them. You can absolutely have a copy of those agreements where we have them. That's free of charge currently. It would have to be the current property owner who inquired to us, or a third party who was nominated and working on their behalf, and the contact details are on the slide there. And I believe these slides will be shared with you at the end of the presentation. So if you want to make a note of that, that email address, that will be on those slides. So to bring that to life a little bit, I wanted to start with a couple of worst case scenarios, a couple of horror stories. So if I draw your attention to the photo on the left-hand side of the picture to start with, I'm sure you may have all picked up on what the glaring issue is with this one, but this is a tunnel that runs beneath Bristol, so it's one of our really large foul sewers. And to the top right-hand corner, I'm not sure if you can see my mouse, but I'm sort of hovering over it, there is a pile. So a piling foundation has gone straight through one of our trunk sewers, and that, I won't name the hospital that was being built at the time, but needless to say, they didn't follow the procedures as they should have done. The pile went through the sewer. It's quite an interesting case, actually, because that pile still remains in situ to this day. It was deemed to be a greater risk to the asset to actually remove it entirely, because the remainder of the bricks, because it's a brick sewer, could potentially have unzipped. So we've actually built bricks up around that, and to allow the hydraulics to work as efficiently as they can do. But that pile is still there, and needless to say, it cost the developer a significant sum to put that right. On the right-hand side, completely different case study. Here, there was an extension built over what is quite a large diameter stormwater sewer, which you can hopefully see towards the bottom right-hand side of that photo. They built over that without going through the process, without securing the agreement that they needed. And then that sewer subsequently developed issues, which led to that issue, led to Wessex Water becoming aware of it. The sewer had to be diverted in the end at the landowner's cost, and they had to incur those costs because they had put up the structure without consent, and it had caused the operational issues that we then had to solve. And so as a consequence, the liability was on them to put that right. So as I'll stress, these are very rare circumstances, but they are worth bearing in mind. So moving on to the main part of today's presentation, which is on historical build-over scenarios. So this focuses on specifically part 2.7 of the Con 29DW, where I'm sure you're familiar with the question concerning whether there is sewerage undertaker consultation or approval with regards any building that appears to be over or close to a public sewer. So as I understand it, if the answer to that is yes, in most cases that will not normally be of any concern, as long, of course, as the homeowner has followed the conditions of that agreement and has obtained any other approvals that they might have required, such as building regulations, consent, and so on. But if the answer is no, and you were to receive a plan as part of the Con 29DW, which did suggest that a new building may be over or close to a sewer, then that might raise some legitimate questions, such as should there have been an agreement with Wessex Water, and also what might that mean for the future liability and risk that might be taken on by a homeowner, by a prospective purchaser of the property. So before we go into a bit more detail about whether you would have needed an agreement, I'll just recap by saying it is any structure within 3 meters that would require an agreement, but there are some legitimate exceptions to consider where there could be a completely logical explanation as to why a building might be over a sewer, which seems to be a public sewer, where there would not have necessarily needed to have been an agreement, and Wessex could not penalise someone for not having an agreement that they didn't need in the first place. So I'll explain that a little bit further through the following examples. To start with, a lot of the time, the sewers are what I describe as like local sewers. They are sort of locally serving the houses with which they were built to serve, essentially. So the houses get built, the sewers go in at the same time. Now, a lot of the time, we ask developers or require developers to place those in excess of 3 meters from the original buildings, but that's not always possible, and it certainly didn't always happen through time. So if there is a scenario like I've drawn up on this slide, where there is what looks quite likely to be the original building, and it's been built within 3 meters of a sewer that was installed at the same time as that building, there would be no requirement for a build-over agreement to exist, because a build-over agreement only needs to exist when you build something new next to an existing Wessex public sewer. So in this case, certainly there would be no expectation that there would be a build-over agreement. And so if you had the answer no on the Con 29DW, that should not in of itself be a concern. The second scenario is one that is much more commonly encountered, and one I'm sure you would have come across, which is where the sewer is public now, but it might not have been. It might have been a private sewer when the structure in question was constructed. So if we look at this property here that I've highlighted, it looks like there is an extension that's gone over what is shown to be a public sewer. And if that pipe was private when the extension was built, then there would have been no requirement to speak to Wessex Water, no requirement to have a build-over agreement, as therefore no concern if it said as much on the Con 29DW. In modern day times, at least, all that would have been necessary would have been for them to go through the to get the appropriate planning permission and building regulations requirement that was required for their development type, and any matters to do with the sewer would have been dealt with through that process. In terms of practically working out whether a sewer was private when the building was first constructed, it's pretty difficult, to be honest. The drainage law is has evolved considerably through time, and so I would always recommend contacting us if there's any doubt. If the sewer is shown on our records, then we will be able to tell you when it was adopted. But if the sewer is not shown on our records, we have to use a series of triggers or look through the legislation and try and work out when that pipe is likely to have been installed, and therefore when it is likely to have been adopted. So what I've put up on the slide here is a very condensed history, or at least recent history, of drainage law. And if I draw your attention to the two main blocks, which are the two mass adoptions. So there was the first mass adoption was in 1937, where a whole series of previously private sewers that had been installed by developers and were adopted overnight. And that is very similar to the one that happened much more frequently on the 1st of October 2011, those sewers are known now in present day times as the Section 105A sewers. And they were adopted on the 1st of October 2011, and they swept up anything that had been installed as a private sewer between 1937 and 2011. And to give you a bit of context on that, overnight on the 1st of October 2011, Wessex Water adopted roughly 30,000 kilometres worth of previously private sewers. So this is an issue that you can encounter quite frequently. So it's worth bearing in mind. And in terms of putting this into practice, using that earlier example I gave for the most part, sewers come along at the same time as the building, because they are at the end of the day serving that building. You could make a few broad assumptions. So if a house was built in the 1930s, which was before the first mass adoption, but then you knew that the extension that was concerning you was built in 1960, that is after that major adoption. It's in between those two dates. Therefore, whilst it's not guaranteed, it is more likely that that extension was built over what is what was then a public sewer because it had been adopted. A second scenario would be if the house was built in 1970, but the extension was 1995. It's in between those two mass adoptions. Again, no guarantees, but it's more likely that that extension was built over a private sewer. Certainly the likelihood is higher. And the third scenario is very similar to the first, where and you get the general picture here. In this case, the extension was built after the second mass adoption, and it increases the likelihood that that was a public sewer when that extension was built. But as I say, if you're in any doubt, please do come through to the team here at Wessex. We're very happy to help identify when a sewer is likely to have been adopted, and then using the date that you will hopefully have from your client around when the extension was built, we can work together to establish whether that sewer was private or public at the time. A final example, well, no, sorry, third example on this theme is to do with how old the structure is. So due to the way that regulations have evolved over time, and indeed records may have been lost when when, like, for example, the local authorities, as they were beforehand, when it was all converted to the regional authorities that we know present day, that basically the older the structure is, the more difficult it is to establish what was required, and also to locate the records. So to give a little bit of context, in 1945 there were as many as 1,400 organisations involved in sewerage disposal, and it was only in 1974 that the regional authorities that we know today, Wessex Water, South West Water, Thames, and so on, we were all formed in 1974. And even at that point, certainly in the Wessex Water region, we still had the previous organisations, the local authorities, handling matters concerning build-over agreements, and that's what we refer to as the agency arrangement. And that was going on, broadly speaking, between 1970. That was handed back to us, between 1978 and 1996. And I know that the 1996 was when Bristol City Council handed those powers finally back to Wessex Water, so for us to deal with. So our records are very good from 1996 onwards, but anything older can get quite difficult. And so I'd always recommend that you contact us if that's the circumstances that your client faces, and we'll do our best to help. Finally, on the 20th of September 2018, we took a look at our processes and decided to use a risk-based approach to eliminate to treat the simplest of cases in a different way. And so that's what we now know as our self-certification process. And effectively what we've done is we've come up with 6 key criteria, which I've published there on the screen, that if the homeowner can meet those criteria, they can effectively declare that they do so, and therefore self-certificate their build, and they would not therefore interact with Wessex Water in any way. They can do this all online, and they would not have a build-over agreement. But in this context, they would not have needed one because they've been able to self-certify. So as long as they've made a valid declaration, then there would be no expectation that they would have a build-over agreement. And therefore, going back to that original point around the answer being no on the Con 29DW, in these circumstances, that would equally not be a concern. So I'd always recommend speaking to the current landowner to understand whether they've gone through this process and they've done so legitimately, as that would again mean that there would be no issue, at least as far as Wessex Water was concerned. I think the next point to talk about, though, is that if there's no agreement in place and there is no sort of legitimate reason which would logically explain why there wouldn't be, and this scenario does occur, we do have the odd one where genuinely someone has built over a sewer without following due process. We've had a few where they haven't gone through planning or building regulations either. In those circumstances, then it is a genuine case where they should have had consent, but they chose not to go through the process. And in those cases, we would consider it to be an illegal structure. There would be certainly be implications and potential liability for the current landowner. And in a worst case scenario, whilst fulfilling our sort of statutory obligations to maintain our sewer network, we could potentially remove that building and not rebuild it. This, as I say, is, I'm at pains to say, is not a common scenario, but it is the worst case. In terms of putting things right, if you engage with us, then retrospective approval is possible in some cases. I know that there's also the option to insure against that risk, but I think that would mean that the client couldn't engage with us, because I think you can't get the insurance if you do so. But if you did engage with us, our retrospective approval process broadly would include asking the homeowner to dig trial holes to complete, so that we could see how the foundations had been installed adjacent or alongside the sewer. We'd ask for a camera survey to be completed so that we could see the condition of the asset and whether the extension or other building had any detrimental impact on it. There would be a form and fee, and we would also potentially require a variety of works to be completed to bring that building up to the required standards before we would consider issuing any kind of retrospective consent for the work. So I wanted to finish the topic of historical buildovers with this slide. What I've attempted to do here is to, as clearly as possible, show the differences in our approach between where a building has an agreement and where one doesn't have an agreement. And obviously, as I put on the right-hand side, in this context, when I talk about agreement, I'm also referring to those scenarios where there's a legitimate reason why a building doesn't have an agreement. So if we start with who is responsible for the sewer, whether a building has an agreement or it doesn't, that remains the responsibility of the water and sewerage company. That does not change. And in terms of who pays for that maintenance, if there was an agreement, then it would be Wessex Water. But if there was no agreement, then we could look to recover any excess costs. So the example I often use is if there was a sewer running through an open field. Currently, we would have really easy access to dig down onto it if it was required to complete a repair. However, if an illegal structure had been built which impeded us from doing so, and it increased our costs, maybe as a worst case scenario, we had to divert the sewer instead of simply dig down and fix it, then Wessex Water would reserve the right to recover those excess costs, the additional costs that we incurred because the building was located in that position. Moving on to the second point, which is, can a structure that is sort of over a sewer be damaged or removed in order for us to access a sewer, in order to fulfill our statutory duty? The answer is yes in both cases. Like, even if you have an agreement, that doesn't change that. But what it does change is how we would treat that situation once it came to the question about reinstating the building. Certainly, if you had an agreement or there was a legitimate reason why one wasn't existing, then Wessex Water would, of course, put that building exactly back to how we found it, in fact, probably to a higher standard, and we would foot the bill for that. It happens rarely, but it does happen, and we would absolutely do that. But if there was an illegal structure, then that would certainly not be the case. We would potentially even not rebuild the structure, and we certainly wouldn't meet the associated costs. So yeah, I hope that's helpful in terms of summarizing our position and the key differences between the two. I wanted to finish on looking to the future. So I know and many of your clients will be interested in potentially developing a property once they buy it. And to be honest, at this early stage, it's quite difficult to give any certainty. But what I'll try and do is explain how we think and the things that we look out for, which I hope will be helpful. So as I say, anything within 3 meters of a typical sewer requires consent. When we receive a proposal, we will review it and look at whether we would allow the structure to go over the sewer, close to it, or for the sewer to be diverted. The diversions would tend to be required in cases where the sewer is of greater strategic importance to Wessex, as long as it can be done without affecting the hydraulics too much. There's a process and procedure to follow no matter which route we go down. As I touched upon earlier, there's the self-certification route for the genuinely simple cases where the risk is really, really low. But for everything else, then they would need to apply for an agreement, and invariably that would end up being an exchange of letters between us and the homeowner with a series of conditions that we'd ask them to meet with regards the type and position of their foundations and any work that needed to be done to the sewer before the building was constructed. I think the most helpful thing that I can give at this stage is to say that there are certain red flags to look out for, because obviously I can't say without looking at an individual proposal what we could or could not accept. But what I can say is there are circumstances where it's much more difficult. So those circumstances tend to be any commercial or industrial development or large scale domestic. Normally the default position with those is that you need to be meeting the minimum easement or diverting the sewer if that's not possible. The same would apply for rising mains. So rising mains are pumped sewers. They are pumping waste uphill, normally at pressure. So they're at pressure in a similar way to our water supply network. And so we treat our water supply network and our sewer rising mains in the same way, in that you cannot build close to them in any circumstances. There's too much of a risk to the property if they were to burst, and it's too much of a risk to us. With strategic assets, as I say, then both strategic assets and rising mains are marked clearly on our records, which should be issued to you as part of the Con 29DW. Strategic assets, for the most part, cannot be built over. We do occasionally allow it in inner city brownfield areas, especially where they've been built over in the past as a historical thing. Normally, large commercial customers would have the funds and for it to make it workable, because it's quite a onerous process that we need to go through because of the importance of the assets to Wessex. So I'd say that for domestic customers, it's not really possible, although you will very rarely find strategic assets within domestic land. And finally, access chambers. So those are the manhole chambers that I was speaking about earlier. They cannot be built over because we then wouldn't be able to get to them. Historically, a lot of private manhole chambers have been sort of built over and double sealed. Wessex doesn't allow that for public manhole chambers. We would ask them, normally it's an issue that can be gotten round. So if you had an access chamber that was directly where you wanted to build an extension, in most cases that manhole chamber can be removed and rebuilt at the homeowner's cost. The only circumstances where that might not be possible would be, for example, where the manhole chamber was located over a significant change in direction or a change in gradient on our line, because that's the whole reason that the manhole is there, is because a significant change in direction, let's say a 90-degree bend, is where there is an increased risk of blockage. So we'd have to review that on a case-by-case basis. So these are just the key things that you can be looking out for at the early stage and before your client has purchased a property. And that was it. So I hope that was helpful, and I'm very happy to take any questions. I'm not sure what the format's going to be for that, so I'll hand back over. Thank you.
Thanks, Chris, and also Ali and Libby. I'm just having a look. At the moment, we don't have any questions. It would appear in the chat box. Here we've got chat box from Libby. Yes, copy of slides will be coming to everybody. I mean, certainly, I'm not a property lawyer, but it seemed to me that there is a great deal of information available from you all there, and so thank you very much indeed for that. We've got a couple more minutes on the clock, so if anybody does have a question or a comment on anything they've heard, please do feel free to put those into the box. The other thing I would say to you all is I'm sure that at both Wessex and Landmark, if anybody's got any questions and want to take them up sort of separately, that I'm sure you're very happy to have discussions about that. Oh, so we've got one question here. If you could confirm how, if the client does not know, do we ascertain? If the client does not know, do we ascertain if there was a build-over agreement in place? That one for you, Chris.
So if that's the, so just so I understand, so if that's the client, if the client doesn't know whether they have one or not.
Yes, how do you ascertain if there's one in place? I think that's the question from Roxy. If that's not the case, Roxy, do let us know.
So we have very good records dating back to at least 1996, and some still have records but slightly less good before that. So I would recommend that you contact us if you're comfortable doing that, and we would be very happy to let you know, because we can interrogate our systems and some old databases to work out whether there's an agreement or not, and yeah, we could then feed that back to you.
That's lovely, thank you. And I think, yes, you confirmed that was the question. We've got another one from Lucy here. Will there be another mass adoption in the future, do you think?
Good question. Yeah, I've often thought that. I personally have the view that there will be. I think what was supposed to happen on the 1st of October 2011 was there was a sister piece of legislation going through government that was supposed to make it mandatory for any new drainage arrangement that created either a lateral drain or a sewer, a shared sewer, where it would be mandatory to offer that for adoption to the Water Authority. That happened in Wales. So in Welsh Water's area, it's now, they are not creating a new private sewer network. So it's working well there. But in England, the legislation didn't pass. And therefore, yeah, you're quite right in what you say. We are slowly but surely creating a new private sewer network. And so who know, I would estimate then, yeah, in the next 70 or 80 years time, the same old problems may reoccur, which is what led to the original sewer transfers. And yeah, there may well be another one. So yeah, it's far from ideal, but that's the position we find ourselves in.
Great, thank you very much. Any more questions or comments, please do put them in. Thank you. We've got some nice comments there about to our speakers to say thank you very much for the session, very informative, and for taking the time to present. Absolutely welcome. I would say to everybody listening, if there are any other subjects, or topics, or items of interest that you would like to hear in relation to the whole conveyancing process, environmental issues, that sort of thing in the future, you know, by all means do get in touch, and either with Wessex or Landmark, or through our contacts with local barristers' chambers, land registry, etc. You know, we're very happy to put on information that you're going to find useful. So, oh, here we go. There's another one here. Is there any way we can find out if a sewer was private at the time of construction of an extension without contacting Wessex Water, as this would invalidate the possibility of obtaining indemnity insurance by contacting you? I'm not sure if I read that very well. I can read that again if that would help. Is there a way? You got that?
No, that's fine. Yeah. No, I understand the question. I'm puzzling. Yeah, it's difficult. It's a good question. It's a difficult one to answer. I think, yeah. I think the answer is probably, in many cases, no. I can't think of a definitive way that you could determine that without contacting us. And I understand the dilemma around indemnity insurance. Unless you made some kind of anonymous inquiry, I'm not sure on the legality. I'm not sure whether that would overcome the issue. The only other thing I can think of is that we make our records available online. So there's an online service through our website, and I could add a link to that onto the slides once they get shared, although they may be in PDF form. Yes, so I could add a link to that so that you could find that easily, and you could, I think, in cases where the sewer was not shown on the records, or even when it was, you may be able to use the general guide that I provided you know, with those case studies where I showed where the building was constructed, and you basically you could use when the existing house was constructed as an indicator and its relative position to the sewer transfers. I don't think it would give you an exact answer, which is what you might well need. So sorry if that sounded a bit waffly, but I think in summary it's difficult. But I'll try and provide the link to our asset records on the presentation slides, and hopefully that will help.
Wonderful. Thank you very much indeed for that. I think that is it. As I said, any other questions that may come to mind when we share the recording and the slide, please do get in contact with Ali or Chris or Libby to discuss any of these matters, or indeed anything else that crops up. I know they'll always be pleased to speak to you on these matters. So without further ado, I just want to thank all of our speakers today for a really informative session. As I say, the comments coming in, it sounds as though it's really hit the mark. So thank you very much indeed. And yes, we very much look forward to welcoming you again. Do let us know, as I said, if there's anything else you'd like to see us present on. And in the meantime, thank you very much for taking the time to join us today, and I hope you have a very good afternoon. Thank you.